Hi, my name is Sherry Renner. This actually is my statement because not only have I been helping pro se litigants for many years, now I find myself one as well. I am representing myself in the Northern District of Florida in a civil rights Americans with Disabilities Act lawsuit against the Florida Bar and the Florida Supreme Court. I'm representing myself because I can't afford to hire an attorney, just like so many of the people who I help and who I have helped over the years who couldn't afford to hire an attorney. I couldn't afford to hire an attorney, but of course I am fortunate enough to have legal training and experience that I can draw from to represent myself and to bring claims against the defendants in my action. In addition to my current pro se status in the Northern District of Florida, I also was pro se in the proceedings before the Florida Board of Bar Examiners that led to my probationary or conditional admission to the Florida Bar. And I was also pro se in my dealings with the Florida Bar with regard to trying to have the conditions on my admission lifted. So all the proceedings before the Florida Board of Bar Examiners, before the Florida Supreme Court, in communication with and litigation against the Florida Bar, I've been pro se. So I have represented myself in all of those, and again, currently I do. So I'm speaking not only from the perspective of someone who helps pro se litigants, but I'm here to talk from my own perspective as well. The last time I had visited the Florida Supreme Court website, I was so surprised to see on the header of the website, the words there that I saw, which considering how the Florida Supreme Court has treated me, are, to me, ring so hollow that they amount to nothing more than propaganda. And what are those words that have stood out to me in such a way that I want to focus my statement about? Accessible, fair, effective, responsive, and, oh, this is my favorite, accountable. Those are the words. Those are the words that I want to talk about. And I'm going to spend my statement for National Pro Se Day talking about. And here are my thoughts on the word accessible. Is a nod actually to the Americans with Disabilities Act itself. The word accessible can actually mean open to anybody who might be protected under the Americans with Disabilities Act. Accessible means that if somebody happens to have some physical challenges, they can still get into the courtroom building. If someone has hearing difficulties, then there may be technologies or perhaps an interpreter who would be available to help that person to participate in proceedings or observe proceedings. Same thing with someone who might be visually impaired. And also by using the word, especially on the header of your website there, you're basically saying, you're announcing to the world that you comply with the Americans with Disabilities Act. So by using the word accessible on your website, you're advertising to the world that you comply with the ADA, but you created a system of attorney regulation that burdens attorneys protected under the Americans with Disabilities Act without allowing for a confidential, predictable review procedure. So I tried to access the court, you, in the only way contemplated under the regulatory scheme that you created. And you punished me in the worst way you could. It's 2 years later, and the devastation to my life still hasn't reached bottom. Accessible? No. The next word that you use here to describe yourself is fair. What does fair mean? According to dictionary.com, fair means free from bias, dishonesty, or injustice. How can you find so many other non-ADA protected attorneys in contempt of court, even for violating disciplinary orders, and still not disbar them, yet destroy my career and everything I've spent years working toward for a purported offense that hurt no one and didn't even constitute a defiance of your authority? How is that free from bias, dishonesty, or injustice? It isn't. So, accessible? No. Fair? No. Effective? Oh yeah, I'm gonna go ahead and give that one to you. You are very effective in destroying my life. Next word, responsive. A full year before I forced the issue with the bar, I communicated with the Florida Bar about the absence of a procedure that I or any second-class attorney could invoke to initiate a judicial review of our conditional statuses. The bar never responded substantively to my concerns, but did loop in the court's legal office into the emails. So I know you know about my concerns. Did you respond to my concerns by providing me with a procedure? By directing the Florida Bar Board of Governors to create a procedure? By accepting your own responsibility for neglecting or failing to create a judicial review procedure? And then accepting my strategic noncompliance for what it was, the invoking of a procedure in the only way contemplated under your rules? But you did none of those things. You weren't responsive. You were rigid, draconian, and outrageously punitive. So, accessible? No. Fair? No. Responsive? No. Last but not least, you claim to be accountable. After failing accessibility, fairness, and responsiveness, I have taken you to task. I have sued you. And what have you done? What have your lawyers done? Have you stopped and reflected, reconsidered, reinstated me, apologized, made it right, accepted the consequences, whatever they were? No, you did not. If your lawyers can find a way to get you off the hook legally, and there is no shortage of ways for them to do that. If they can do that, they will. And you'll walk away and you all will pat yourselves on the back on a good win. Anything other than the actual merits of my cause of action against you, the actual merits, the heart of what you've done wrong. And what you've done wrong, you still haven't made right. Not for me, and not for anybody else who stands in a position similar to mine, or what mine used to be. Have you written a procedure for others? No, because you don't want it there. You want that trap. So, accountable? Absolutely not. So all of these words, accessible, fair, responsive, accountable, they're empty and hollow. It's nothing but propaganda. It's marketing. It's window dressing. That's all that it is. Until you make this right, until you accept responsibility for what you've done, for the wrong you have done, all of this is just marketing. So what does this have to do with National Pro Se Day and my pro se status? A lot, I think. If I had had an attorney representing me in the proceeding before the Florida Board of Bar Examiners, would I have been presented with as harsh an agreement for a conditional probationary admission status as I was? Did you see someone who was not represented and think, let's burden her, let's load her down with as many conditions as we possibly can get away with? If I had had an attorney, would my conditional admission have been as harsh as it was? I doubt it. I doubt it. If I had an attorney from the beginning representing me in my case against you in the Northern District of Florida, would you have tried to resolve the case by now? Simply because not only are you now exposed to potential liability for destroying my career and my reputation and ability to earn an income, but you would also be on the hook potentially to pay their attorney fee, to pay the attorney fees that I incur in that representation. So the fact that I'm pro se, does the fact that I'm pro se in that case as well spur continued attempts to shirk responsibility and remain unaccountable for what you've done to my life? I think it does. I think it probably does. Because the attorney fees that would be collectible under the ADA for me as a prevailing party would be significant and definitely part of your risk-benefit calculus, wouldn't it? That's why this has to do with Pro Se Day. I still help pro se. I've helped pro se litigants almost my entire legal career, and I still do. So many people have had their faith in the system dashed, destroyed. And I don't blame them one bit, because guess what? So has mine. And here I am, spending so much of my time helping them, which helps you. But I'm right there with them. What are you going to do? Are you going to allow this condition to continue? Or are you going to step up and do the right thing? For me, and also as an ambassador to the pro se community across this country. So what are you going to do? It's within your power to do something to restore my, and by extension, other people's faith in the civil justice system. Access to civil justice doesn't just mean pro bono attorneys, expanded legal aid, legal insurance. It doesn't just mean making the world or keeping the world, doing everything you can to keep America safe for attorneys. It also means fairness. It just means honoring the rights of every single person to petition their government for a redress of grievances without regard to their status of being represented or not. So what are you going to do? And I just want to say to all the pro se people out there who have listened to this all the way to the end, I believe in you. I have always believed in you. You're smarter and stronger than you think you are, and you can do this. And the legal establishment will have a reckoning sooner or later. and it will come through us. Thank you.